After my son's death, my daughter-in-law laughed. "I'll take all of your son's property. You'll get nothing. I made sure of it." But the notary said, "There is one last clause." When she heard about my fortune, she fainted. Good day, dear listeners. It's Clara again. I'm glad you're here with me. Please like this video and listen to my story till the end, and let me know which city you're listening from. That way I can see how far my story has traveled. My name is Dorothy Callahan, and I am 71 years old. I have lived long enough to know that grief does not arrive all at once. It comes in waves. First the phone call, then the funeral, then the silence of a house that used to hold laughter. My son, Robert, was 43 when he died. A heart attack. Sudden, senseless, the kind of thing that makes you question every prayer you ever whispered. He had been healthy, or so we all believed. He jogged on Saturday mornings. He ate salads. He kissed me on the cheek every time he visited and called me Mom the way only he could, with that particular warmth that belonged to no one else in the world. Robert had been married to Melissa for 11 years. I want to be fair when I describe her, because fairness matters to me even now, even after everything. She was attractive in a calculated sort of way, always dressed precisely, always saying the right thing in company. When Robert first brought her home for Thanksgiving, I thought she was simply reserved. My late husband, Gerald, used to say, "Dot, not everyone warms up fast. Give people time." So I gave her time. 8 years of it, to be exact. 8 years before I allowed myself to name what I was seeing. Our family home, the house on Sycamore Lane in Ashford, Connecticut, had been in our family for 37 years. Gerald and I bought it young, raised Robert in it, buried Gerald from it. When Robert married Melissa, he moved 2 towns over into a modern colonial that Melissa had chosen. The house on Sycamore Lane remained mine. Gerald had been meticulous about legal matters. Everything was clearly written, clearly signed. Or so I believed. Robert visited me every Sunday. That was our arrangement, and for the first 6 years of his marriage, Melissa came with him. Then, gradually, she stopped. Headaches, work, commitments. I didn't press. I was simply glad to have my son. The first sign I missed was small. About 2 years before Robert died, he came for Sunday dinner and seemed distracted. He barely touched his pot roast. When I asked him if everything was all right, he said, "Melissa wants us to revisit the will, Mom. She thinks things should be more organized." I asked what that meant. He looked uncomfortable and changed the subject. I should have pressed harder. I didn't. The second sign was the attorney. About 14 months before Robert's death, a man named Gerald Fitch, no relation to my husband, left 2 messages on Robert's phone while Robert was sitting in my kitchen. Robert stepped outside to call him back. He was gone 20 minutes. When he came back in, his face was composed in that particular way. People compose their faces when they don't want you to read them. I asked who Gerald Fitch was. Robert said, "Just a legal thing, Mom. Nothing for you to worry about." I was a retired school teacher. I taught English for 34 years. I knew when someone was editing the truth. But grief has a way of making you rewrite the past with the clarity you didn't have when you were living it. At the time, I told myself I was being paranoid. Robert was a grown man. He had his own affairs. He had a wife. He died on a Tuesday in March. I got the call at 6:47 in the morning from Melissa herself, and I want to say this honestly. Her voice sounded shocked. Whatever else she was, she hadn't expected to be a widow at 41. I drove to the hospital in a daze. I held Robert's hand, already cold, and I said goodbye the best I could. What followed were the worst 3 weeks of my life. The funeral arrangements, the casseroles from neighbors, the sympathy cards I couldn't read without breaking apart. Melissa handled the public logistics with an efficiency I told myself was her way of coping. Then came the day that changed everything. It was a Thursday afternoon, 3 weeks and 2 days after we buried my son. Melissa called and asked me to come to her house to discuss the estate. I put on my good gray coat. I drove over. I sat at the kitchen table where Robert and I had eaten Christmas dinner just 4 months earlier. Melissa poured herself coffee, didn't offer me any, and sat across from me with a smile that didn't reach her eyes. "Dorothy," she said, "I want you to understand that I have been very thorough." She slid a folder across the table. Robert updated his documents 18 months ago. Everything. The accounts, the investments, and yes, the house on Sycamore Lane. It all transfers to me. I had an attorney handle it properly. You'll want to make arrangements to sell. I looked at her. I looked at the folder. And then she said the words I have never forgotten. "I'll be taking everything that was your son's. You'll get nothing. I've made sure of that." She was smiling when she said it. Genuinely smiling. And in that moment, sitting in my dead son's kitchen, I felt something shift inside me. Not just grief, not just rage. Something cold and clear and absolutely certain. She had made a mistake. I didn't know yet exactly what it was, but I knew, the way a woman knows after 71 years of reading people, that Melissa had made one. I drove home from Melissa's house in silence. I didn't turn on the radio. I didn't cry. I gripped the steering wheel with both hands and focused on the road. Because if I let myself feel everything at once, I would have pulled over and never started again. When I got back to Sycamore Lane, I sat in the driveway for 11 minutes. I know it was 11 because I watched the clock on the dashboard. Then I went inside, made myself a cup of chamomile tea, sat at the kitchen table, my kitchen table, the one Gerald had built by hand from a kit he ordered out of a catalog in 1987. And I allowed myself to think. What had I actually lost? The accounts. Robert had his own savings, his 401k, his checking account. Those had always been his. I had no claim there, and I had never expected one. But the house on Sycamore Lane was different. Gerald had left it to me. It was in my name. It had always been in my name. Melissa couldn't take something that was already mine. Could she? And yet, she had slid that folder across the table with such confidence, such precision, the kind of confidence that comes from having already spoken to lawyers, from having already planned several steps ahead. She had said Robert updated his documents 18 months ago. Gerald Fitch, the attorney who had called Robert's phone in my kitchen, the conversation Robert had stepped outside to have. I set down my teacup and pressed my palms flat on the table. Was it possible that Robert had been persuaded, or pressured, to sign something that affected my home? Robert had loved me. I was certain of that. But Robert had also been a man who avoided conflict the way some people avoid bad weather. He had been gentle, accommodating, more comfortable with harmony than confrontation. Melissa knew that. Melissa had spent 11 years learning exactly how to move the furniture of his decisions without him noticing. The fear arrived then. Not the sharp fear of a sudden shock, but the slow, settling fear of someone who has just realized the ground beneath them might not be solid. I was 71 years old. I was on a fixed income, my teacher's pension, and Social Security. The house was not just sentiment. It was my security. If Melissa had somehow encumbered it, leveraged it, or worse, if Robert had unwittingly signed something that gave her a claim, I could lose everything Gerald and I had built. Was I going to sit here and let that happen? I thought of my friend Louise, who had been a paralegal for 22 years before she retired. I thought of the public library 3 blocks away, where I had spent 34 years recommending books to children and teenagers. I thought of every student I had ever taught to break down a problem into its component parts before panicking about the whole. One step at a time, Dorothy. The first thing I needed was information. Not Melissa's version of information. Actual, verifiable, legal information. I needed to see what Robert had actually signed, and whether any of it could legally affect property that was already in my name. That evening, I called Louise. She answered on the second ring, and I told her everything. The folder, the smile, the words Melissa had said. Louise was quiet for a moment. Then she said, "Dorothy, the first thing you need to do is pull your own deed. Go to the county recorder's office and request a copy. If the house is still in your name with no liens or encumbrances, she can't touch it. But you need to see the paper." I wrote that down. "Second," Louise continued, "you need a probate attorney, not a general practice lawyer, a probate specialist, someone who handles estates and inheritance disputes. Robert's estate will go through probate regardless of what Melissa claims, and you have standing as a parent to at least understand the documents." I wrote that down too. "And third," Louise said, her voice softening, "do not speak to Melissa again without having spoken to an attorney first. Not one word about any of this. Let her think you're beaten." That last instruction came naturally to me, because Melissa already believed I was beaten. She had watched me sit across from her with that folder pushed in my direction, and she had seen what she expected to see. An old woman, stunned and helpless. She had no idea that the stunned old woman had gone home and made a list. The next morning, I was at the county recorder's office when it opened at 8:30. The clerk, a young man with a patient manner, pulled the records for the property at 14 Sycamore Lane, Ashford, Connecticut. I looked at the deed. My name, Dorothy Ann Callahan. Sole owner, no co-owner listed. But then the clerk frowned slightly and pointed to a second document attached to the record. "There's a lien filed here, ma'am, about 16 months ago. You weren't aware of this?" A lien against my house. Filed 16 months ago. Gerald Fitch's name was on it. I stood very still at that counter while the young clerk printed me a copy. And then I walked to my car, sat in the driver's seat, and for the first time since Robert died, I allowed myself 1 full minute of pure, cold fury. Then I picked up my phone and called a probate attorney. The probate attorney's name was Catherine Marsh. Louise had recommended her. She's sharp, she's patient, and she does not tolerate nonsense. And the moment Catherine Marsh shook my hand in the doorway of her office on Elm Street, I understood why Louise trusted her. She was perhaps 55, with silver-streaked hair pulled back cleanly and reading glasses on a chain around her neck. Her office was orderly without being cold. She offered me coffee before I had even sat down, and I accepted it gratefully. I told her everything. I started with Robert's death and went forward, and then I circled back to the phone call, Gerald Fitch, the folder, and finally, the lien. I put the recorder's copy on her desk. Catherine examined it for a long time without speaking. Then she took off her reading glasses and looked at me directly. "Mrs. Callahan, this lien was filed by Gerald Fitch on behalf of a client, listed here as Robert J. Callahan." She paused. "Did your son ever mention taking out a personal loan or using property as collateral for a financial arrangement?" "Never," I said. "Did he have any business dealings that might have required collateral?" "Robert was a project manager for a construction firm. He had a salary. He wasn't an entrepreneur. He had no reason to—" I stopped. "Unless someone gave him a reason." Catherine nodded slowly. "I want to be careful about what I suggest, because at this stage we have a document and a name, not a full picture. But what I can tell you is this. A lien filed against a property you solely own, without your knowledge or signature, is potentially fraudulent. To file a valid lien against your property, your signature would have been required. or the filing would need to allege a debt that you personally owe. Do you owe Gerald Fitch or any associated entity any money? Absolutely not. Then we have grounds to challenge this lien. And if we can demonstrate it was filed under false pretenses, with forged authorization or fabricated debt, that becomes a much larger legal matter than an inheritance dispute. I felt the first real breath of solid ground beneath me. Catherine filed a formal challenge to the lien within the week. She also submitted a records request for the full probate file on Robert's estate, which Melissa had initiated through a different attorney, a man named Stover, who had an office in Hartford. Meanwhile, I had returned to my ordinary life as much as I could. I went to church on Sunday. I had lunch with Louise twice that week. I watered my garden, which was starting to push up the first stubborn green of early spring. But I was also watching. And so, apparently, was Melissa. On the Wednesday of that week, my neighbor Patricia, 73, sharp as a tack, and the closest thing I had to a lookout without ever intending to be one, mentioned that she had seen an unfamiliar car parked on Sycamore Lane twice in the past 4 days. A silver sedan, sitting for 30 or 40 minutes at a stretch. Probably nothing, Patricia said. But you know how I notice things. I knew how Patricia noticed things. I thanked her and said nothing more. That same evening, my phone rang. It was a number I didn't recognize. I answered it. The voice on the other end was male, measured, and professional in the way that people are professional when they want to sound neutral but are delivering a message. Mrs. Callahan? My name is Andrew Stover. I represent Melissa Callahan. I'm calling as a courtesy to let you know that our office is prepared to proceed with the estate distribution, and we hope to avoid any unnecessary delays. We understand you've made some inquiries with the county recorder's office. So, she already knew. Mr. Stover, I said, you'll want to direct any further communication to my attorney, Catherine Marsh. A brief pause. Of course. We simply wanted to... Good night, Mr. Stover. I hung up. My hand was steady. The next morning, Catherine called me with news that made me sit down. Her records request had returned the probate documents, and among them was a copy of the amended will Robert had signed 18 months before his death. It restructured the estate, yes. That was Melissa's doing, and it was legal. But attached to that file was something else. A letter from Gerald Fitch's office referencing the lien on Sycamore Lane as collateral established by Robert Callahan in support of a spousal financial agreement. A spousal financial agreement, not a debt, not a business loan. A spousal agreement, meaning the lien was intended to give Melissa a future claim against my home as part of some arrangement between them. Except, and this was the point that made Catherine's voice go very quiet when she read it to me, the letter referenced my signature as having been obtained. I had signed nothing. Ever. Dorothy, Catherine said carefully, I need you to think very hard. Did you ever sign anything for Robert in the last 2 years? Any document at all? Even something he described as routine? I thought hard, and then I remembered. 14 months ago. Robert had come for Sunday dinner and brought a folder of papers. He'd said there was a refinancing thing he needed a witness signature on, just a formality. His notary was a friend who would come by the following week. I had signed where he indicated, without reading carefully, because it was Robert, because it was a Sunday, because the pot roast was getting cold, and I trusted my son completely. Catherine, I said, I think I signed something I didn't read. That, she said, is exactly what I suspected. And if that signature was obtained under false pretenses, if Robert didn't fully understand what he was having you sign, or worse, if he was directed to obtain your signature without disclosing the true purpose, then we have our evidence. Point of no return. Catherine moved quickly after that. She filed a formal complaint with the Connecticut Bar Association regarding Gerald Fitch's conduct, specifically, the filing of a lien based on a signature obtained without informed consent. Simultaneously, she petitioned the probate court to freeze any distribution of Robert's estate, pending a full review of the amended documents. Both actions were filed on the same morning, and by that afternoon, Gerald Fitch's office had called Catherine 3 times. I was not present for those calls, but Catherine summarized them for me crisply. Fitch had claimed the lien was entirely legitimate, that I had signed voluntarily, that the spousal agreement was a private arrangement between Robert and Melissa, into which I had entered knowingly. He was, Catherine said, very confident. The confidence of a man who had done this before and gotten away with it. I had anticipated this. So had Catherine. Which was why, 3 days earlier, I had gone to my bank and requested copies of every transaction in the joint witnessing arrangement Robert had described. There were none, because no refinancing had ever occurred. And I had written out, in full, a detailed sworn affidavit describing the circumstances under which I had signed the document. Date, time, what Robert had told me, what I had believed I was signing, and the fact that no notary had been present that day, despite Fitch's letter implying formal witnessing. No notary. That was the crack in their foundation. Fitch's letter stated the signature had been notarized by a commissioned notary in the presence of both parties. I knew with absolute certainty that no notary had come to my house that Sunday. I had been home all day. Patricia next door had brought over a pie at 3 o'clock and stayed for an hour. She would remember. Patricia remembered everything. Catherine submitted the affidavit and a supporting statement request to Patricia. Then came Thursday. I was in my garden. The daffodils had come up, which felt both comforting and unbearable, because Robert had planted that bulb bed with me 6 years ago, when I heard a car in the driveway. I looked up. Melissa's car. And behind her, stepping out of the passenger side, a man I didn't recognize. Large, formal suit. He was carrying a briefcase. They walked toward me across the lawn. Melissa's expression was controlled, but her eyes were sharp with something that had moved beyond calculation into anger. "Dorothy," she said, "we need to talk about what you're doing." "My attorney handles my communications," I said. I pulled off my gardening gloves. "You're welcome to contact her." The man with the briefcase introduced himself as a colleague of Mr. Stover's. He began speaking in a low, even tone about the seriousness of filing false affidavits, about the legal exposure I faced if I continued to contest documents I had voluntarily signed, about how the courts took a dim view of elderly individuals coached by attorneys to misremember events. Coached to misremember. I let that sit in the air between us. "I signed something my son brought me on a Sunday afternoon," I said. "I signed it without reading it because I trusted him. I did not sign anything in the presence of a notary because no notary was present. That is what I have stated. It is the truth. If you have evidence to the contrary, I imagine you'll present it in court." Melissa took a step forward. "You are going to lose," she said. Her voice had dropped the professional coding entirely. "You are going to lose, and you are going to embarrass yourself, and when it's all over, you'll have nothing except this house, which you cannot afford to maintain on a teacher's pension, and we both know it. Let this go, Dorothy. Walk away with your dignity." I looked at her. My son had loved this woman. He had built a life around her. And now she was standing in the garden he had helped me plant, threatening me, while a man in a suit implied I was a confused old woman inventing memories. "Melissa," I said quietly, "please leave my property." She stared at me for a long moment. Then she turned and walked back to the car. The attorney followed. The car reversed down the drive and was gone. I stood in the garden for another minute. My heart was beating harder than I would have liked. I was not as steady as I had appeared. but I had not moved an inch. That evening, I called Catherine and told her what had happened. She filed a formal notice of harassment with the court the next morning and included a request that all future contact be conducted exclusively through legal counsel. After that, I allowed myself to rest. For 4 days, I did very little. I slept later than usual. I read novels, the thick, absorbing kind, the kind Robert used to tease me about. I had Louise over for dinner, and we talked about everything except the case. I watched the spring move across the backyard in the evenings, the light lasting longer every day, and I tried to be still inside it. I was 71 years old, and I was fighting for my home, and I needed to not be exhausted when the real moment came. So I rested, and I gathered myself, and I waited. The offer came on a Tuesday morning, 10 days after the confrontation in the garden. It arrived not from Melissa directly, but through Stover's office, a formal letter delivered by courier, which I thought was rather theatrical for a 3-page document. Catherine called me as soon as she received her copy, and we reviewed it together over the phone while I sat at the kitchen table with my reading glasses and a cup of coffee. The letter proposed a settlement. Melissa, through Stover, was offering to withdraw the lien on Sycamore Lane in exchange for my dropping all challenges to the estate distribution and signing a document releasing any claims I might pursue against Gerald Fitch's filing. In addition, I would receive a one-time payment of $40,000, described in the letter as a gesture of goodwill, recognizing Mrs. Dorothy Callahan's relationship to the deceased. A gesture of goodwill. $40,000 for my silence, for the signature they had already stolen, for Robert's entire estate passing cleanly to the woman who had stood in my garden and told me to walk away with my dignity. I was quiet for a moment after Catherine finished reading. "What do you think?" I asked her. "I think," Catherine said carefully, "that people don't make settlement offers when they're confident they'll win. I also think $40,000 is a number chosen to sound significant to someone on a fixed income. They're guessing at your financial anxiety." "They guessed right that I have it," I said. "They guessed wrong that it controls me." I told Catherine to decline. She drafted the response that afternoon. Polite, brief, final. What the offer told me was something Catherine had also noted. They were worried. The affidavit about the missing notary had landed harder than Fitch had expected. Patricia had submitted her supporting statement. She remembered the Sunday clearly. She had been in my kitchen for over an hour. No notary had come. And now there was a credibility problem in Fitch's documentation that couldn't be papered over with confidence. They were watching me, though. That silver sedan appeared on Sycamore Lane again twice that week. I didn't acknowledge it. I went about my days with deliberate normalcy. I went to the library on Wednesday morning, my old library, where several of the staff still knew me, and I spent 2 hours reading in the periodicals room the way I used to on my days off before retirement. I had lunch at the diner on Main Street, where the eggs were good and the coffee was strong. I walked home the long way. What I was doing, I suppose, was refusing to behave like someone who was afraid. Because fear was a signal, and I wasn't willing to send it. The social support came naturally, as it does in small towns. Ashford was not a large community. 34 years of teaching in the local school system meant that I knew people, not in the way politicians know people, but in the real way, the way that accumulates through parent-teacher conferences and chance encounters at the grocery store and the slow architecture of a life lived in one place. Several families had reached out after Robert's funeral. A few had heard, through the particular osmosis of small-town news, that there was some kind of legal dispute. One afternoon, my former student, now in his late 30s, a man named Daniel Farrow, who had become a real estate attorney in the next town over, stopped by the house with his wife and a casserole. He said carefully that he had heard I was dealing with a property matter, and that if I ever needed a second opinion from someone who knew Connecticut real estate law specifically, he was available. I thanked him genuinely. The following Sunday at church, 3 women from my Bible study group sat with me after the service and let me talk. Not about the legal details, I was careful about that, but about Robert, about losing him, about the particular loneliness of being 71 and suddenly having to be formidable. One of them, Eleanor, squeezed my hand and said, "Dorothy, you were always the strongest person in that classroom. Don't you forget that now." I didn't cry until I got to my car. But it was the good kind of tears, the kind that release something rather than drain it. And on the drive home, with the spring afternoon settling golden over the Connecticut hills, I felt something I hadn't felt in weeks. Not happiness, not yet, but steadiness. The kind that comes from knowing you are not alone, that people who have known you across decades are watching and quietly cheering, that the life you built has roots deeper than one woman's scheme. Melissa and her lawyers could have their silver sedan. Let them watch. They would see a 71-year-old woman living her life. And they would see that she wasn't afraid. They came on a Saturday morning in late April. I was in the kitchen making oatmeal when I heard the car. I looked out the window and saw Melissa's vehicle, and this time she was alone. No attorney. No large man with a briefcase. Just Melissa, in a soft cardigan I hadn't seen before. Pale blue, the kind of color chosen to project approachability, walking up the front path with something in her hands. A pie. She was carrying a pie. I set down my spoon. I took one slow breath, and then I went to the door and opened it before she could knock. "Melissa." She looked up. Her expression was different from the garden confrontation, softer, arranged into something that resembled remorse. "Dorothy, I know I should have called, but I was afraid you wouldn't agree to see me, and I think we need to talk. Just the two of us. Without lawyers." I considered her. She held out the pie, blueberry, from the look of it. "I made it myself," she said. "Robert always said you loved blueberry." Robert had told her that. That small, true detail was precisely the kind of detail designed to disarm me. "Come in," I said. We sat at the kitchen table. I made tea. I did not serve the pie. Melissa sat with her hands wrapped around her mug, and she began. She told me she was sorry, that she had handled everything badly after Robert died, that grief made people do terrible things, and she had been scared. Scared of being alone, scared of financial instability, scared that Robert's family would contest everything and leave her with nothing. She had made decisions she regretted. Fitch had been overzealous. The lien had been his idea, not hers. She had trusted him, and he had gone further than she intended. It was a very good performance. Emotionally calibrated, factually plausible in certain surface ways, and delivered with exactly the right degree of visible effort, as if she were working to hold herself together. I watched her, and I listened. I did not interrupt. When she paused, I asked, "What is it you'd like from today, Melissa?" She took a breath. "I'd like us to settle this between ourselves. Family. Without the courts making a mess of everything Robert left behind. I'm prepared to release the lien, have Fitch withdraw it entirely, and I'm willing to give you access to Robert's personal items, the things from his childhood, whatever you want. In exchange, I just need you to step back from the probate challenge. Let the estate settle the way Robert wrote it." I nodded slowly. "And the complaint against Fitch with the Bar Association?" A slight tightening around her eyes. "That too. Yes." There it was. The real purpose of the soft cardigan and the blueberry pie. Drop the bar complaint. The bar investigation was the one thread that, if pulled, wouldn't just affect my case. It would expose Fitch to professional discipline, potentially expose the full mechanics of how he had operated, and raise questions about other clients he might have served in the same fashion. "Melissa," I said. "I appreciate you coming. I can see this is difficult." She leaned forward slightly. "Dorothy, we're both Robert's family. We both loved him. Can't we—" "What was the notary's name?" I asked. She blinked. "I'm sorry?" "The notary. The one listed in Fitch's letter as having witnessed my signature. I've been trying to track down the record. What was their name?" The color in Melissa's face shifted in a way she couldn't control. Just a half second. Just enough. I don't remember. That was Fitch's office. Because, I continued quietly, my neighbor Patricia was in this house the entire afternoon I supposedly signed that document, and neither of us recalls a notary. And a notary's commission is a public record. I've been looking. Melissa set down her mug. The softness left her face entirely. Not dramatically. She was too controlled for that. But steadily, the way light fades at the end of a day. "You know," she said, and her voice was different now. "You're making this much harder than it needs to be. You're an old woman living alone. You don't need this fight. I am trying to give you a graceful way out." "Thank you," I said. "I'll let my attorney know you came by." She stood. She picked up her purse but left the pie on the counter. Whether that was oversight or a final small message, I never determined. She walked to the door, and at the threshold, she turned. "You'll regret this, Dorothy." "Perhaps," I said. "Goodbye, Melissa." I closed the door. I stood with my back against it in the quiet hallway, and I will be honest. I was frightened. Not of Melissa herself, but of the specific vulnerability of being old and alone and dependent on a process I couldn't fully control. The fear was real, but it was also fuel. I picked up my phone and called Catherine. I told her everything, word for word. She listened without interrupting and then said, "She came to kill the bar complaint. That tells us exactly what they're afraid of." I already knew. I made fresh tea. I looked at the pie on my counter, the blueberry pie made with a true detail and a false heart, and I left it there, untouched, until I threw it away the next morning. The hearing was scheduled for the second Thursday in May. It was not a trial. Probate proceedings rarely look like what people imagine when they think of courtrooms. It was a hearing before a probate judge, in a room that felt more like a conference space than anything dramatic. Fluorescent lighting, a long table, lawyers on both sides with their folders and their careful faces. Catherine had prepared me thoroughly. "You may be asked to speak briefly. Answer only what is asked. Don't elaborate. Don't fill silences. Let me do the work." I wore my dark blue dress, the one I had bought for Robert's college graduation and worn to Gerald's funeral and to every significant moment in between. It fit me the same as it always had. I sat beside Catherine with my hands folded, and I was quiet. Melissa sat across the table with Stover, and behind him, Gerald Fitch. Fitch was a small man, 60s, with very clean fingernails and the practiced stillness of someone who had sat in rooms like this many times before. He had not looked at me when he came in. Melissa, beside him, was composed in that particular way of hers, the careful arrangement of a person who has rehearsed their expression. But I noticed, even before anything was said, that she had chosen the wrong color. She was wearing black, which in a probate hearing carried its own unintended message, the widow asserting her claim. I wondered if she had chosen it deliberately, or whether it had simply been habit by now. I noticed these things because 34 years in a classroom had trained me to read a room before I opened my mouth. Stover opened the proceedings on their side by asserting the validity of the lien and the amended will, and by characterizing my challenge as a grieving mother's understandable but legally unfounded attempt to contest clearly executed documents. He was polished. He used the phrase emotionally motivated twice, which I thought was precisely calibrated to diminish without appearing cruel. Catherine responded by presenting the evidence in order. Methodical. Unhurried. First, the affidavit I had written, describing the Sunday, the folder, what Robert had told me, the absence of any notary. Second, Patricia's statement, corroborating the timeline with specific detail. She had been in my kitchen between 2:40 and 4:15. She had seen no notary. She had seen only Robert and me. Third, the bank records confirming that no refinancing transaction had ever occurred on the property, which demolished the explanation Robert had given me for the document. Fourth, and this was the piece Catherine had saved, a records request to the Connecticut Notary Public Database. The notary listed in Fitch's letter as having witnessed my signature, a woman named Carol Dewey. Catherine had located Carol Dewey. Carol Dewey had submitted her own statement confirming that she had never traveled to 14 Sycamore Lane, had never witnessed a signature from Dorothy Callahan, and had never been retained by Gerald Fitch's office for any purpose whatsoever. She had, in fact, never heard of Gerald Fitch until Catherine's office contacted her. The name on the notarization had been fabricated, invented, placed on a legal document with the full knowledge that the real Carol Dewey would likely never know, and that an elderly woman grieving her son would likely never think to check. The room went very quiet when Catherine read that statement aloud. Fitch's expression did not change, but his hands, which had been resting flat on the table, moved slowly to his lap. Stover leaned over and murmured something to him. Melissa, across the table, was absolutely still. The particular stillness of someone who has just heard the floor crack beneath them and is deciding whether to move. Furthermore, Catherine continued, we have obtained a statement from Robert Callahan's former colleague, James Whitmore, who had a conversation with Mr. Callahan approximately 20 months ago. In that conversation, Robert indicated that he was under significant pressure from his wife regarding a property matter involving his mother, and that he was, and I'm quoting from Mr. Whitmore's statement, not entirely comfortable with the direction things were going, but didn't know how to stop it. Robert. He had known something was wrong. He had felt the current pulling and hadn't found the bank in time. That knowledge was its own kind of grief, separate from everything else, and I allowed myself to feel it for exactly the moment it took Catherine to turn the page, and then I set it aside. Stover objected on relevance grounds. The judge sustained in part, but noted the statement for the record. Then the judge looked at Fitch directly. Mr. Fitch, can you explain the discrepancy between your letter's reference to notarization and the statement from the commissioned notary? Fitch cleared his throat. I believe there may have been a clerical error in the correspondence. The notarization stamp on the document, the judge said flatly, is not a clerical error. It is either authentic or it is not. Another silence. Longer this time. Melissa leaned toward Stover and spoke in a low, urgent voice. Stover shook his head slightly. She spoke again, and I could see from the set of her jaw that she was not making a request. She was issuing an instruction. Something between them was unraveling, and it was visible now. The precision of her control was cracking at the seam, the careful performance of the composed widow giving way to something harder and less rehearsed underneath. Then Stover said something I don't think he intended to say. He began a sentence about the document being prepared in good faith and got tangled in it, circling back, self-correcting, adding qualifications that undermined the qualifications before them, which in a room full of careful listeners is the sound of someone whose story has more seams than they remembered when they dressed in the morning. Melissa reached out and touched his arm to stop him. She looked across the table at me. She was trying to read me, I think. Trying to find the frightened old woman she had seen in the garden, the one she had calculated into her plan from the very beginning, the grieving, isolated, financially anxious widow who would take the $40,000 and sign the release and disappear quietly back to her house on Sycamore Lane. I met her eyes, and I was simply calm, not triumphant, not angry, just present, the way I had been present in 34 years of classrooms when a student finally broke and told the truth. That patient, unhurried stillness that comes from having done the preparation and being willing to wait as long as necessary for the truth to finish arriving. The judge called a 30-minute recess. In the hallway, Catherine touched my arm. "They're going to fold," she said quietly. "Fitch knows the bar complaint is active and that the fabricated notarization has just become a matter of public court record. He is not going to let this go to a fraud finding in open court. That would be the end of everything for him." I nodded. I went to the water fountain. I drank. I straightened my dark blue dress, the one that had seen every significant moment of my adult life, and I walked back into that room. When the hearing resumed, Stover requested to approach the bench. What followed was a conference between the attorneys and the judge that I observed from my seat. Their voices low, the judge's expression unreadable, Stover's posture losing its straightness by degrees. Fitch sat at the table and did not participate. Melissa sat beside him with her hands flat on the table and her jaw set. After 12 minutes, Stover returned to the table. He sat. He opened his folder, closed it, and then looked up with the specific expression of a man who has just negotiated a controlled retreat. "Your Honor," he said, "the respondent's counsel is prepared to withdraw the lien on the property at 14 Sycamore Lane in its entirety, effective immediately, in recognition that the filing contained documentation that cannot be substantiated." The judge looked at him for a long moment. "Mr. Stover, the court notes that withdrawing the lien does not resolve the question of how it was filed. The fabricated notarization is a separate matter that the court is referring to the state's attorney's office for review." Stover nodded once, carefully. "Understood, Your Honor." And that was the sound of it. Not a bang, not a speech. Just a nod in a fluorescent-lit room, and the structure Melissa had built, the careful, layered architecture of manipulation and forged documents and a blueberry pie, came down. Catherine submitted the probate challenge formally. The judge, reviewing the evidence that Robert's signature on the amended will had been obtained under circumstances involving undue influence. The statement from James Whitmore was placed into significant context here, alongside evidence Catherine had quietly compiled about Melissa's control over Robert's financial and legal decisions in the final 2 years of his marriage, ordered a full review of the amended will's validity. It took 6 weeks. 6 weeks during which I went about my life on Sycamore Lane, and May turned into June, and the garden that Robert had helped me plant came into its full color. The review determined that the amended will had been executed under conditions consistent with undue influence and was therefore void. Robert's estate would revert to his original will, the one he had drawn up before Melissa had gotten to it, which left his personal savings and accounts to be divided according to his original wishes, with a specific bequest to me of the contents of his home office, which I had not known about, his books, his drafting tools, a framed photograph of the two of us from his college graduation, and, tucked inside a copy of a novel I had given him for his 30th birthday, a handwritten note that said simply, "Mom, just in case. I'm sorry I wasn't braver. Love, R." I read that note in my kitchen on a Tuesday morning in June, and I sat with it for a long time. As for the rest, Gerald Fitch surrendered his notary sponsoring privileges and entered into a consent agreement with the Bar Association that included a formal censure, mandatory supervision, and probationary conditions that effectively ended his ability to practice in the areas he had specialized in. The state's attorney's office opened a formal inquiry into the fabricated notarization. I was told by Catherine that the inquiry was proceeding, that I might be asked to give a statement, which I was fully prepared to do. Melissa did not go to prison. I want to be clear about that. I am not telling a story where everything resolves into perfect cinematic justice. What happened was this. The estate was restructured. The fraudulent lien was expunged from the public record. The amended will was voided. Melissa retained what she had brought into the marriage and her legal entitlements under the original will, which were modest, because Robert had been modest, and she had been planning around a document that no longer existed. Stover dropped her as a client within a month of the hearing. I learned that from Daniel Farrow, who had kept quiet ears open at my request. The last thing I want to describe is the moment after the hearing, in the courthouse parking lot. Melissa was walking to her car. I was walking to mine. We passed within 20 feet of each other. She stopped. I stopped. She looked at me for a moment with an expression I found difficult to name. Not quite hatred, not quite shame. Something more complicated than either. "You had help," she said finally. "Yes," I agreed. I had Louise and Catherine and Patricia and Daniel and Eleanor and James Whitmore and 34 years of students who learned to tell the truth. Yes, Melissa, I had a great deal of help. She said nothing to that. She got in her car and drove away. I stood in the parking lot in my dark blue dress in the June sunshine, and I breathed. The summer after the hearing was the first summer in 2 years that I slept through the night. I don't mean that metaphorically. I mean that from sometime in early July, I began sleeping the way I had before all of this. 6, sometimes 7 hours, uninterrupted, waking to the particular quiet of Sycamore Lane in the early morning with something that felt, if not like peace exactly, then like its near cousin. Relief. The unclenching of something I had been holding for so long I had forgotten I was holding it. I repainted the front porch that summer. It had needed it for 2 years, and I had kept not getting to it. And then one Saturday morning in August, I drove to the hardware store, chose a deep colonial red that I thought Gerald would have liked, and spent a weekend painting it myself. Slowly, with breaks, but myself. Patricia came over and helped with the railing posts, and we talked the whole time about nothing consequential, which was exactly what both of us needed. Daniel Farrow and his wife had me over for dinner in July and in September. He had young children, twins, 5 years old, who climbed on the furniture and argued loudly and reminded me, with a kind of sweet ache, of every child I had ever taught. He told me, carefully, that the state's attorney's inquiry into Gerald Fitch had progressed and that charges had been filed, document fraud, among other things, and that there were indications the case had attracted attention because Fitch's practice had involved similar maneuvers with at least 2 other clients in the previous several years. My case had been, it seemed, the thread that unraveled a larger fabric. I don't say that with pride. Only with the particular feeling of someone who did the right thing and found, to their surprise, that it mattered beyond themselves. The house on Sycamore Lane was refinanced that fall, properly, through a legitimate lender, to fund repairs that had been deferred too long. The furnace, the upstairs bathroom, the back fence that Robert had promised to fix and never gotten to. I signed every document in full and understood every word. I thought about that Sunday afternoon, the folder Robert had brought, the page I had signed without reading because I trusted him. I thought about it without anger toward Robert. He had not fully understood what he was being used to do. His note said so. I'm sorry I wasn't braver. He was brave enough to leave the note. That had to be enough. I visited his grave in October, on what would have been his 44th birthday. I brought the yellow tulips he had always liked, the real ones, not the hothouse kind, and I sat with him for a while and told him about the porch and the furnace and the twins who climbed the furniture at Daniel's house. I told him Catherine Marsh was extraordinary and that he would have liked her. I told him that Patricia still brought pies, real ones, with love in them, and that I could tell the difference now. As for Melissa, She moved to Hartford after the estate was settled, with significantly less than she had planned for. The social position she had constructed around being Robert Callahan's wife, in a community where the Callahan name meant something quiet and decent, evaporated with the legal proceedings. People knew. Small towns always know. She had taken a position at an insurance company in Hartford. Not what she had envisioned, but real work. Gerald Fitch's professional collapse meant that any future plans involving him were moot, and Stover, when he dropped her, had kept his fees regardless. The legal costs had been substantial. Gerald Fitch was convicted on 2 counts of document fraud in the spring following the hearing. He received a suspended sentence and was permanently disbarred. He was 64 years old and his career was over. Did I feel sorry for either of them? People ask me this sometimes. I think about it honestly. For Fitch, very little. He had done this to other people before me. He had been willing to help a woman defraud a 71-year-old widow of her home. Whatever consequences arrived, he had selected them. For Melissa, something more complex. I think she had watched Robert be gentle and accommodating and had chosen to see weakness rather than kindness, and then organized her entire plan around a weakness that didn't exist in the way she thought. Robert had been gentle. He had also, at the last, left a note. I kept that note in the book where I found it. It sits on my nightstand now, next to Gerald's photograph. On a cold evening in November, sitting by the fireplace I finally had serviced properly, I poured a glass of wine and thought about what the year had cost and what it had given back. It had cost me my naive belief that grief was the only thing I needed to survive. It had cost me the comfortable assumption that love is sufficient protection. What it gave back was my home, my standing, and my certainty, renewed and clarified, that truth spoken clearly and supported by evidence is not a naive ideal, but an actual force in the world, and my dignity, which no one had managed to take, though several had tried. They say grief softens with time. What I've learned is that it doesn't soften. It deepens into something you can carry. I lost my son. I almost lost my home. I did not lose myself. If someone tells you that you'll get nothing, listen carefully. They may be showing you exactly what they fear you'll take back. Don't sign what you haven't read. Don't trust what you haven't verified. And never underestimate a woman who has already survived everything she thought would break her. What would you have done in my place? Thank you for staying with Dorothy's story to the end.